Because, Your Honor, I object to
What
the fact
do you
that
not
it's calling it a
understand?
no
Sir,
RB.
your objections mean shit to me. So you keep saying, I object, I object, I object. I don't care. I don't care what you're objecting to. I'm going to hold you in contempt the next time you cut her off.
Well, I do object to the setting aside of my motion, Your Honor.
I'm not setting aside your motion. I'm denying your motion.
Well, denying. I object to the
You
denying.
can't object. You can appeal. Brother, why'd you just waste 5 minutes of my life?
Alright guys, today we've got a sovereign citizen who really thinks he can outsmart a judge with made up nonsense, but trust me, this judge is not having it. No games, no BS, just straight facts. Watching this guy argue fake rules against real law while the judge calmly shuts him down is pure gold. It's honestly a masterclass in patience and logic. I'll never understand why sovereign citizens think they're above the law when the law couldn't care less about their fantasy theories. Let me know in the comments if you think the judge nailed it or if he should have gone even harder. Let's dive in.
You got a motion filed?
Yeah, yes, absolutely. I actually have issues to discuss before I cross.
But the court reporter needs to take you up.
Here, you don't have to be at the podium, but at least have a seat at that table where that microphone is.
Threat, coercion, and I'm under duress. I'll cross.
You're under duress. How are you under duress?
Well, Your Honor, as stated in my motion, there's actually fraudulent word that says unsigned by a judge. I have lawsuits filed on all of this stuff right now, which I know that they received.
Hold on, brother. Wait. I'm just asking you to have a seat at the chair with a microphone.
Oh, I understand that. I'll do it. Okay. The front check or something.
That's fine. Just make sure you talk to the microphone.
Absolutely.
Okay. All right, you can sit down. Okay. So I think this is your motion to dismiss, right?
Yes, I have a few in there that I've been repeatedly trying
Okay,
to be
well, which
dismissed.
one do you want to start with first?
Well, the recent one I filed, the motion to reject swearing in and all that based off the fact that, like I said, I was sent a default motion that, I don't know how it even got sent out past did, but it was never signed or anything. I was also defaulted out the fact that there was a citation.
Before we even get into the substance of this hearing, you can already feel the tension crackling through the courtroom. This isn't just another traffic case, this is a full-blown clash between reality and ideology. On one side, you've got a judge who knows the law, lives in the law, and has zero patience for procedural chaos. On the other, a self-represented defendant leaning hard into sovereign citizen-style arguments, objections without purpose, theories without grounding, and a belief that saying the right word somehow bends the legal system to his will. From the opening seconds, the judge makes it crystal clear, this courtroom runs on rules, not vibes. Objections don't stop rulings. Motions don't magically revive themselves. And most importantly, legal outcomes don't change just because someone refuses to accept them. What you're about to see is a masterclass in judicial restraint, firm, controlled, and relentlessly procedural, as the court patiently dismantles confusion piece by piece. The real question is not whether this defendant believes he's right. It's whether belief alone can survive contact with actual law. Spoiler alert, it usually doesn't.
I never even presented a court appearance.
Okay, hold on. You're giving me too many issues. You're talking about swearing in, you're talking about a default judgment. Just pick one issue. We're going to deal with them one at a time. So what do you want to deal with first?
Well, my main motion. Well, yeah, the default.
Okay, so was that on the civil infraction, failed to disclose the CPL?
I suppose that's what it was under, yes.
Okay, don't suppose, it's your motion, brother. Tell me what it is.
Well, it keeps getting
that's the only civil infraction.
I have numerous. I have lots of stuff.
Hold on, that's the only civil infraction I see with your name on it. So I'm just confirming that we're talking about that charge.
Yeah, sure.
Okay. So do you know why the default was entered? Did you miss a deadline? Did you
I was notified. I was called by people that I know within Huron and the police chief stating that I had a missed appearance date. I never had an appearance date scheduled. I went back looking at the citation. There was no date. And actually how fast it got issued raises real concerns to me. And then once I received the default in the order.
Hold on. Let's take one thing at a time. So you said you never got an appearance date.
Correct.
Do you have a copy of the ticket? Because I've got a copy.
Yeah, I said it's in there. It's attached to my motions.
Okay. Do you have a copy of the ticket?
I do.
Okay. Then I'm going to ask you to look at that copy of the ticket. Because my copy of your ticket says contact court for appearance date.
It says contact court for appearance date. Where it says appearance date on or before, there's nothing.
Okay, but it says contact court for appearance date. That means the monkey's on your back to contact us.
I will also on the bottom of the tickets, it says if you fail to contact court within the specified amount of time. There was no specified amount of time on here. I had no idea what I was supposed to contact court. I was dealing with trying to get my attorney.
Let me ask you this. Did you contact the court?
I was again, as I said, I had no sort of any time frame to contact
Mr.
court.
Crucell, this is going to go a lot easier on everybody if you just answer the question I asked. I'm going to give you plenty of chance to give me any argument you want to give. Okay? So don't feel that you have to force your argument into every question I ask. The question was, did you contact the court?
Well, Your Honor, I would have contacted the court if I had a specified.
That's a yes or no. So I'm going to take that as a no. You didn't contact the court. So after 14 days on a civil infraction, if we don't hear from the defendant, we enter default.
It was less than that, actually, when I was defaulted, Your Honor.
Less than that from what?
From whatever this was issued. And like I said, I was contacting.
Well, once again, I'm going to draw your attention to the ticket. My ticket, which I think is the same one you got, is dated February 3rd.
Correct.
Okay, so that's when it was issued, February 3rd.
Correct.
So when was the default? When did you get notice of a default?
Actually, I received, I'm sorry, I know I got the thing in the mail. When did I get this? This says that.
This exchange right here sets the tone for everything that follows. Notice how the judge immediately narrows the focus. The defendant wants to unload every grievance he's ever had: fraud, lawsuits, defaults, citations, conspiracies, all at once. But courts don't work like therapy sessions. They work one issue at a time. The judge isn't being dismissive, he's being surgical, and this is where a lot of self-represented defendants stumble. They assume volume equals strength. In reality, clarity is power. The judge repeatedly asks a simple question: which motion do you want to address first? And instead of answering, the defendant keeps circling the runway. That's not strategy, that's avoidance. Courts don't reward scattershot arguments. They reward precision. And every time the defendant refuses to lock into one issue, he's giving the judge more reason to control the pace and tighten the reins.
I don't think it specifies a date.
Well, did you make a note when you received it?
This told me, this said I don't remember exactly what date I received this in the
Okay.
mail, but this was scheduled for March 8th.
Okay.
So that was even less than.
Well, what is that that's scheduled?
This says it was for my order, the motion affidavit saying that I was defaulted and saying that I needed to pay bond and an orange warrant would be issued. And I said,
Okay.
again, that was never.
And that's dated what?
This was dated 3/8. I needed to appear
Okay.
on or before 3/8.
Okay, so that was March 8th. You were defaulted February 22nd.
Okay. Which then, again, there was no dates. I had no nothing. I had no
Okay.
notice of any sort of.
Once again, you're not hearing what I'm telling you. The monkey was on your back. The ticket clearly said you contact us. You never did.
And it also specifies right here, if you fail to appear by the date specified, and then on the bottom one, even for the other one, if you fail to answer a citation by date specified, there was no dates.
Okay,
There was no dates.
okay. Do you have anything to add?
I do, Your Honor.
Go ahead.
Mr. Crusoe brought this up when we were in front of the Honorable Judge Martin. She did set aside the default of civil infraction, irregardless of whether or not he showed up.
Which I object to the setting
Sir, do
aside.
not interrupt the lady. Did she interrupt you?
No, yeah.
Then don't do that. Let's be civil. Go ahead.
Thank you, Your Honor. Judge Green, Mr. Crusoe did bring it up again with the Honorable Judge Green, and she declined or denied his motion based on the fact that it was moot because Judge Martin set it aside.
So the default's already been set aside.
Yes,
Brother, why'd you just waste 5 minutes of my life?
since March 14th, Your Honor.
Which I object to that because they.
You object to your motion being
No, I
granted?
object to them setting aside my motion. And I object to this.
No. Wait. Listen. She tells me Judge Martin set aside the default based on your motion.
Yes, but I was never told any of that prior to any of that.
So you want to argue about the fact that you got what you asked for?
But what I'm saying is the fact that the due process was violated is what happened in this whole problem. When I was defaulted, due process was violated.
So what? She set it aside.
Not, listen, it was set aside to cause damages to me because of what happened with the default.
Well, explain to me how you were damaged.
First off, there's threats made against me, right? Clearly he's threatening me to issue
No.
warrants,
I didn't ask you
threatening to
about
pay
threats.
money.
I said, how were you? You said you were damaged. I'm asking you, what was the damage?
But the fact that I was threatened to come in and pay money or warrants.
How was that damage?
And I was being threatened by Huron Police, which I have on record.
What's the damage?
What do you mean? The fact that I had to come in and pay money or I would have been, there'd have been issued.
What money
warrants.
did you pay?
Huh?
What money did you pay?
$280. I had the receipt and everything. It was all attached to my motions. They just keep trying to set it aside. And Judge Green never said a word to me about any of that.
It's been set aside. Counsel just said, Judge Martin set aside the default. So what that means is procedurally, it's like it's a brand new file. Understood?
Yeah, but that's but that, especially now with the new showdown overlay, that's just saying that she's just trying to set it aside that there's no issues.
She didn't try to set it aside, she sat it
But she
aside.
can't. She can't just set my right to.
This moment is critical, and a lot of people miss why. The judge asks a yes or no question. Did you contact the court? That's it. No traps. No tricks. Just a factual checkpoint. And the defendant can't answer it. Instead, he explains, justifies, rationalizes, everything except answering. Here's the thing. In court, explanations don't substitute for answers. When someone refuses to answer a direct question, judges are allowed to draw conclusions. That's exactly what happens here. The judge reasonably infers that no contact was made, explains the default process step by step, and anchors it to dates. This isn't opinion. This is procedure. The law doesn't pause because someone is confused, busy, or philosophically opposed. Deadlines exist whether you acknowledge them or not, and the court's patience starts thinning when someone keeps arguing the premise instead of addressing the facts.
She's not setting your rights aside, she set a default aside because you asked her to.
Well, so if it's set aside, then the money should be returned, correct?
Well, I don't know, did she address the money?
No, she never did. No one did. I
Sir,
explained in my motion.
Sir, I'm gonna hold you in contempt the next time you cut her off.
There it is. That's the kind of judge we need to deal with these fools. To be fair, replaying that clip, it might have been unclear whether the judge was talking to him, but come on, this guy is still a total tool. His arguments are all over the place and make zero sense. He seriously needs to stop talking or get a lawyer because nothing he's saying is grounded in law. At least the judge shut him down this time. Let's dive back in and see if he tries to interrupt again.
The first contempt's $100. The second contempt's a day in jail. Are we clear on the ground rules for my courtroom? Is that a yes for the
Yes, Your
record?
Honor.
Okay. I'm giving you all the time you need to talk. Don't talk over her.
Okay, I understand. I'm sorry. There's just been a lot that's been going on with this.
And I'm the first time I'm seeing it, so I'm trying to get to the bottom of it.
You're right.
All right. So we started with what motion do you want to talk about first? You said your motion to set aside the default. That was granted by Judge Martin, is what I'm hearing from the prosecutor. So that motion's done. Would you agree?
As long as my money gets returned, then I guess it's taken
At
care
some point, trust me, your money will either get applied or returned. Next motion you want to talk about.
the dismissal based off of fundamental violations of my fundamental rights and due process.
Okay, well, tell me more.
Okay.
You have, hold on, let me just cut to the chase. You have more than just the fact that you think you have a right to travel.
Yes, Your Honor. Actually,
That's denied. I'll just cut to the chase. That's denied. I don't buy into that argument. Now, you can appeal that decision to the circuit court. You understand how that works? District court decisions, you can appeal.
absolutely.
Okay, hold on. I've denied that motion. We're not going to talk about that motion because I've denied it based on your argument that you have a right to travel and don't need a license. Is there anything else you want to hang your hat on for dismissal?
Well, I do object to the setting aside of my motion, Your Honor.
I'm not setting aside your motion. I'm denying your motion.
Well, denying, I object to the
You
denying.
can't
of the motion.
object. You can appeal.
Well, I'm just
Okay.
letting you know, I'm stating for the record that I am objecting to your denial of my appeal.
That's fine.
Okay.
Circuit court judges have bills to pay too, right? So you appeal me to the circuit court. Do you have any other argument why these cases should be dismissed?
That's absolutely, well, honest, Your Honor, like I said, I even have both lawsuits. They've received my lawsuits to the Huron Township Police Department overall.
Hold on. I don't know anything about a lawsuit. How would you suing the township work as a reason to dismiss these charges?
Because the initial traffic stop and everything was unlawful stop from the get. I was
Okay, but that's got
retaliating.
nothing to do with your lawsuit. That might be the basis of your lawsuit.
And here's the irony bomb that detonates the entire argument. The default? Already set aside. The relief he's demanding? Already granted. And the judge's reaction says everything. Why did you just waste 5 minutes of my life? That's not sarcasm, that's judicial disbelief. This is a classic courtroom cell phone. The defendant is arguing harm from a decision that no longer exists. Procedurally, once the default is set aside, it's like it never happened. The file resets. That's not a rights violation, that's due process working exactly as designed. But instead of recognizing the win, the defendant reframes it as damage. Judges see this all the time, people so committed to the narrative of victimhood that they can't accept resolution. And once that happens, credibility starts bleeding fast.
So you want to talk about whether or not there was a valid reason for
Yeah, absolutely.
then make the argument.
Your Honor, so prior to me being pulled over by this officer, I was actually in contact with several law enforcement officers that are friends, and actually two that are currently working within Huron that had confirmed I had every lawful right to be doing what I was doing. The one even pulled up to me and my wife at a gas station, and we were in town, and we are in Sibley and Middlebelt, right near actually where I got pulled over. And we had discussed it and talked about it, went on about our day, and this was all prior to this incident. I had two other interactions with this officer where I had specifically told him, I've already been confirmed and doing lawful, I'm well within my lawful rights. I have it documented. You need to go talk to the sergeant that I've been talking to and a couple other buddies, right? I gave him that opportunity. It was shortly after that. And I had that confirmation well prior to me even being pulled over. Okay. So then, this officer seen me leaving my house, pulling off my dead end dirt road, proceeded. And like I said, I even told him, I've already had this day. I've already addressed this. You need to go talk to the sergeant.
Right.
Chose not to. Pulled me over, walked up, just started demanding ID and everything from me. He wouldn't identify himself, none of that good stuff. And then now this is where it's all led to. And I informed him, I have body cams, I have my own recording. And like I said, I have a lot.
Okay, but you started out by saying you wanted this dismissed because there was not probable cause for the stop.
Correct.
Okay. And then you went on to tell me how there was obviously a difference of opinion within the department about whether or not what you were doing was legal or not.
Well,
Is that a fair summation?
What was that?
Is that a fair summation of what you just said? Some of the officers that you talked to said you could do that, and obviously the officer that wrote you the ticket didn't think you could.
Correct.
Okay, so that's a difference of opinion there, which has very little, if anything, to do with the probable cause for the stop. So I'm going to let the prosecutor explain her position on probable cause.
Absolutely.
Go ahead.
Thank you, Your Honor. Defendant is requesting this court dismiss the case because of the accusation that operating an ORV on the roadway constitutes a blatant violation of his First Amendment rights and an improper attempt to regulate his constitutional rights. In his most recent motion, he does accurately cite Terry v. Ohio as controlling. This was plainly a Terry stop.
Well, hold on. His argument is there was no reason for the stop.
He does cite Terry v. Ohio in his motion.
Okay.
Because people submit that the investigatory stop exception in Terry v. Ohio controls the validity of the traffic stop. An officer may stop and briefly detain a person on the basis of a reasonable suspicion that criminal activity is afoot. Defendant claims that he was stopped without legal justification. Rather, defendant was stopped for operating an ORV on the roadway in violation of MCL 324.81122 as adopted by Huron Township ordinance. Pursuant to the United States v. Ferguson,